Hi, and welcome to the Law Simplified. I'm Shraveen Bandadnayaka. Before I begin today's video, I'd like to take an opportunity to thank all of you who've been part of the Law Simplified journey for the past 6 years. A little over 6 months ago, I launched the Law Simplified online law school, complete with comprehensive pre-recorded masterclasses, fast-track programs, as well as workshops, supplementary reading material, and the works. This was the culmination of 6 years of experience in teaching students from all around the world. So I thank all of you for helping me cross the 1,000 enrollment mark just about a week or so ago. If you'd like to enroll and join the Law Simplified online law school, which gets updated on a weekly basis based on the actual sessions that I conduct and the know-how that I've accumulated over the past several years, make sure you use the link in the description below or the one that appears on screen right now. But having said that, let's get into the video. The very reason why you may have clicked on this very particular video is because of the title itself. Here's what your examination paper will look like. Now that indicates one very specific thing. You feel as a student of law that every single time that you go into an examination hall or under these circumstances online, that whatever you are going to encounter is new. The reality is far from it. The nature of examination questions, be it in a problem-based format or that of an essay, is far from being novel by any measure. What I mean by that is, if you are able to do sufficient amount of questions throughout whichever subject that you are encountering, chances are you're bound to receive a question which might be similar in the worst case or identical in the best one. Now, what I mean by this in the more broader sense is that whichever scenario that you're presented with and in whichever angle you're questioned, the chances of you being able to tackle it are exponentially higher if you have encountered a question in your practice examination questions. Now, one of the key indicators and something I try to impress upon all of my masterclass and fast-track students is the notion that you must always control the narrative. What do I mean by this? Whichever type of question your examiner tends to throw at you, the idea is to take that, interpret it in your own words and articulate it in your own words and present a response on your own terms. More often than not, when students approach me with the best way to answer questions or how exactly to apply the law, what they're really asking me is, what do the examiners want from me? Now, more students than I'd like to admit to tend to write everything they know about the subject matter that they feel the question is on. This is true if it is a problem-based question or an essay-based question. But in reality, what an examiner wants you to do is to show conviction of response. He or she would like to see if you are able to identify what the question is about, and in the case of a problem-based scenario, what the question is essentially asking of you, and then tackle it head on. Now, there are a number of factors that goes into articulating quite a comprehensive response, most of which I've covered in different aspects in videos that are available on this very YouTube channel, as well as other resources around my ecosystem of the Law Simplified. But in a nutshell, the most important thing in order to control the narrative is to have a properly drafted and presented introduction. Now, an introduction which showcases to the examiner that not only do you know the facts of the matter, but also what you're talking about in terms of the law, and that you are able to articulate the fundamental issues, looks something like this. Your introduction essentially needs to be in 3 parts. Part 1 should identify the parties and their relationship to one another. This is very specific in relation to a problem-based scenario. So if you have a claimant and a defendant, or if you have a victim and a defendant, or if you have, let's say in terms of property law, a landlord and a tenant, whichever these parties may be, it is not enough to simply say that there are two parties, but you must also indicate the relationship they have among one another. Part 2 of your introduction must identify the primary and secondary areas of law. This doesn't need to be specific as such, but should indicate to the examiner the broad strokes of what you're going to tackle. So for example, if you're going to talk about a particular scenario involving murder, you might want to indicate that the broad area of law is homicide, specifically that of murder. If you have already identified in your previous reading what defenses might be applicable, you would indicate those here as well. For example, the potential mitigation of murder by virtue of voluntary manslaughter by diminished responsibility. Part 3 of your introduction is, I would argue, the most important element, which are the fundamental issues to be tackled. Now, in several previous videos, I've tried to dissect what I mean by the fundamental issues. You can check those out through the card that will appear on screen right now or the links in the description below. But essentially, it is you indicating to the examiner that you are aware of the hurdles that you'll have to cross over in order to come to a conclusion as such, in terms of who might be guilty or innocent, or who is liable and who is not. This is the best way to control your narrative. Once you have set up this comprehensive introduction to whatever question that's presented to you, chances are your examiner will understand that you know exactly what you're talking about. It creates the best first impression, and from this point onwards, it's up to you to break down your response based on the fundamental issues that you've broken in the introduction. So, the next time that you think, what is my next examination going to be like, and what questions are they going to present to me, try and turn that argument around and that question around, and start asking yourself, have I done enough questions to be able to encounter a similar thing in an examination? Examinations, or even assignment submissions at that, are not novel instances. Scenarios, for the most part, are finite in nature. Whichever way you look at them, the parties and the circumstances might differ in terms of name and locations. But do enough questions and scenarios, and you're bound to encounter similarities across the board. If you'd like to understand how best to formulate a comprehensive introduction and then follow that through by responding to a particular question that's presented to you from A to Z, I highly recommend looking at the workshop series that's available on the online law school, which you can access through the link that will appear on screen right now. Once again, I'd like to thank everyone who supported the Law Simplified channel thus far and is helping it grow more and more in terms of the content and the ability to assist and aid students from around the world. But having said that, until the next time that we meet, have fun, stay safe, and as always, obey the law.